So, good morning, everybody.
Good morning.
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 Here. For those of you who don't know, we should all go around the table. My name is Bob Freeman, and let's hear from Buffalo. Hi, Jean.
Hi, how are you?
Fine, thank you. And across from you is?
Ron Schwartz. I'm with the licensing division.
Well, then, welcome. And now New York City. I know some of your faces.
I'll start. Franklin Stone. I'm a board member.
Andrew Case. I used to work with Franklin at the Civilian Complaint Review Board.
Thanks for joining us.
Welcome.
I'm Jonathan Dinellen. I'm Deputy General Counsel at the Hearst Corporation.
Hi, John. It's a pleasure to have you with us.
And this is Dave Schultz. I'm another member of the committee.
Yes, we all know that. A critical member, in my opinion.
Yes, I'm not a board member. I'm committee member.
Hi, good morning. Camille Jobin Davis.
I'm Bill Bruce. I'm trustee of the Commissioner of General Services, Roland DeSica.
I'm Andrew Howard. I'm a legal intern from Albany Law School.
Wendy York Briggs, helpful
Ever
person.
helpful.
Amy Ottaviano. I am the budget director designee.
Peter Grimm, committee member.
Peter is the elected official designated by the governor who serves on the committee. We also have on the phone the representative of the Secretary of State, Nina DeSalvo. She has attended meetings in the past. Hi,
everyone. Hello, Nina.
And
Hi, Nina.
Nina can participate, but she can't be counted toward a quorum because she can't be seen, nor could she vote. But my expectation is that there will not be a lot of votes, if any, today. My hope is that we will have a terrific roundtable kind of discussion focusing on Section 50A of the state civil rights law. My expectation is that Dave and Franklin will be pretty much carrying the ball. If that's okay with you, Dave, would you like to introduce the issue?
Sure. Section 50A is an exemption to the FOIA law that probably most of you are aware of, but it's one that has been interpreted by the courts in ways I think that go far beyond what the legislature intended, and has been used by police officers, unions, and others very, very aggressively, and has brought us to a position where, as 50A is now interpreted and routinely applied, it essentially becomes impossible to get almost any information about what police officers are doing. 50A itself says, in substance, that the personnel records, that's the term that's used, personnel records used to evaluate performance towards continued employment or promotion under control of any police agency, and it also covers, I think, firefighters and Department of Corrections personnel and other peace officers. Shall be considered confidential and not subject to inspection or review. And so it's that language. There's two key terms in there. One is that it says all personnel records, which is not defined, but it's essentially been construed as anything that actually is or conceivably could be used to evaluate someone for promotion. And what it says is that they shall be considered confidential, and that has also created a lot of confusion about what that means, whether it can even be used in court if it's gotten through other measures. It's created all sorts of problems. And I thought what I would like to talk about today, and I'm really glad John Dinellen is here, because John has litigated several cases, and I was hoping that he might talk about some of the problems in the courts with this, and then and maybe we'll do that first, and then I'll just walk you through a couple of examples of what seems to me to be a real public policy problem. And as Bob Freeman has said, this is his position, not mine, but one I endorse fully, that we're in a very odd situation in the state, that the state agency that has the most direct impact on the lives of citizens is the one agency that has the least oversight of any agency because of Section 58. It becomes almost impossible to know what's going on and to monitor the activities of police in a meaningful way. And with that, I'm just going to turn over to John and ask him if he would talk about a couple of he's had a series of cases and fights that have gone all the way to the Court of Appeals, and I'd just like him to explain some of the issues that come up.
Sure. I'll talk about two cases. We had one, as Dave said, that went to the Court of Appeals, and the other one that's pending right now, which we got a decision out of the Third Department Appellate Division a couple of months ago. The one that went to the Court of Appeals was interesting because it involved some investigative reporting out of the Albany Times-Union involving members of the Albany Police Department who apparently had used the police department to buy military assault weapons, which are suitable for SWAT teams, for their own personal use, and had taken them and used them for themselves and given them away as gifts. One of them wound up in a used gun store and had been confiscated by the ATF, and that led to an investigation which resulted in the seizure of all the weapons. And what happened to the police officers who had purchased them, nobody knew. There was nothing publicized about it. One of the investigative reporters from the newspaper found out about this, put in a FOIL request asking for all information regarding to these weapons and the seizure of these weapons, and came back with a list of different objections under the Freedom of Information law, not including 50A at that time, but privacy and the like, basically stonewalling it. It led to litigation, and eventually 50A had been, after the case was started, was asserted by the police union. And what it came down to at the end was the only way to identify which police officers had actually bought these assault weapons, which was outside of police approval and channels, was to go to the actual evidence tags which were attached to the weapons after they were confiscated. So the whole case was about getting copies of these evidence tags with nothing more than the police officers' names on it. And when the police union came in and asserted Section 50A as one of the bases to keep them exempt from the FOIL disclosure obligation, we believed that it was a throwaway argument at first. It was so ridiculous on its face, given the fact that these were not personnel records. And in the trial court, we litigated as such, and we lost that. And then we took it up to the Third Department Court of Appeals, and again, we argued that these couldn't possibly be personnel records. There's 3 requirements in the law that they have the nature of personnel records, and we said fundamentally these don't have the nature of personnel records. Second of all, that they're used for purposes of continued employment or promotion. They weren't used as such. And third of all, that they could be used abusively in litigation, potentially. This is what the Court of Appeals has said through the use of the legislative history, to impeach officers in the stand. And by this time, these records were quite stale. They had been, this had happened years earlier, and most of the police officers, we believe, were retired. In any event, there was no showing on the point. And the Third Department upheld the application of 50A there again. So that's where we petitioned the Court of Appeals. The Court of Appeals, we were asking for a sweeping ruling which would basically define 50A as the limited statute that it was intended to be at the outset. And we did get a per curiam ruling out of the Court of Appeals, reversing the lower courts, releasing the records, but at the same time not really discussing in a broader sense what the scope and the limitations are on 50A. That leads us to a case that we have now involving the New York State Police, where a New York State police trooper hit and run a civilian after drinking at a party, and was later released from the force. We don't believe that there's any question that he was released due to this conduct, and that he was responsible for the person's death. And there was a request made by the Albany Times-Union again to the New York State Police for copies of any records relating to this accident after he had already been separated from the New York State Police. And again, the response was that 50A covers this. The trial court upheld that, and the trial court also said that the police officer himself was a necessary party to the case, which is completely contrary to the statute. That would only happen if you had somebody who had, there had been an actual finding that these were personnel records. Then after the fact, if you wish to overcome that, there can be litigation in the context of a case. And this was upheld by the Third Department again. So we not only have the courts who are construing this in a very broad way, but we have the municipalities and the police departments using the statute very aggressively. And in particular, which is very uncommon for us in freedom of information litigation, they are making many motions to dismiss at the very outset rather than getting into the merits. And what this does is it slows down the case. It adds in another layer of appeal and another layer of trial court proceedings. And in each case, the motions to dismiss ultimately have been overturned if they've been granted or they've been denied. So, this is wearing down the press in the sense of trying to use resources to get to this information. As to 50A just generally, for those of you who aren't that familiar with the statute, it has its origins back in the 1970s. And one of the important things about 50A, to my mind, is that it is a belt and suspenders law. 50A is completely unnecessary to protect the interests of the police. 50A was originally sought in the legislature, and the legislative history shows this, because there were criminal defendants who were seeking to get access to police personnel records so that they could attempt to impeach those officers on the stand when they were being prosecuted. And this was a way to cut that off. Of course, courts always have control over their courtroom, and a judge could always limit the scope of any questioning because it is more prejudicial than probative, and could always deny requests for these sorts of records. So in a sense, this is a completely unnecessary statute. To the extent that there have been concerns raised through amendments to cover correction officers about personal private information, there are also privacy exemptions in the FOIL statute, as we know, and so that there are other exemptions that would cover them there. So in a sense, 50A is not really necessary, and what started out as what was designed to be a very limited exemption, and that's what the Court of Appeals said in the earliest cases dealing with it, there's been a scope creep that's gotten much broader. The Court of Appeals actually in an early case, Burns, had said that the two main considerations, which is whether or not it's the nature of a personnel record and whether or not it's been used as one for purposes of promotion or retention, was not enough to limit the scope of the statute. And so they went and they grafted on essentially the third requirement, which comes out of the legislative history, which says that you have to make a showing that this information could be used abusively, meaning used abusively if the officer was testifying in a criminal prosecution. And that third prong, which was meant to limit further the statute, has been used in recent years to broaden its scope, because now courts look to that prong and they say anything that essentially is embarrassing or could be used to abuse people, an officer in the broader sense, should be precluded from production under the FOIL law. And so we have a real problem with that. Between the litigation gamesmanship of making these various motions and between the overbroad reading of the statute, 50A has really been used to frustrate accountability to a significant extent, and that has proven itself in a number of cases.
May I interject just to offer a little bit of background? We have several public employees sitting around the table, and as Jonathan mentioned, there is an exception in FOIL dealing with the ability to withhold when disclosure would result in an unwarranted invasion of personal privacy. Historically, the courts have told us that we public employees have less privacy than anybody else because we are supposed to be more accountable than anybody else. In the context of disciplinary matters, which I think are probably most significant in relation to 50A. If, for example, there is an unsubstantiated allegation regarding a public employee, a complaint, a charge that has never been proven or admitted, that kind of record can be withheld with respect to any public employee. On the other hand, if there is either a finding of misconduct or an admission of misconduct on the part of a public employee, that kind of record is public. And that is the kind of record that has been the subject of several judicial decisions, and for better or for worse, as we've mentioned, that leaves those people who have the most control over our lives. Dave mentioned state agency. This applies across the board to all law enforcement agencies. My town police department is covered by 50A. They have the most control over our lives, but they are the least accountable. So there is a clear distinction in terms of the accountability associated with public employees generally, as opposed to those categories of public employees who are covered by Section 50A. As a matter of fact, our intern, Andrew Howard, did a study to find out what other states are doing in relation to disciplinary records relating to police officers. And the great majority of states, I forget what the number is, you can remind me, the great majority of states treat police officers in the same way as other public employees. So New York is something of an aberration. The other point, and Jonathan mentioned this too, this notion of creep. It started with coverage for police officers, then it was expanded to correction officers. Now it's also professional firefighters and other peace officers. I am concerned that the creep will continue to exempt from disclosure records that are really critical with respect to any number of other public employees. And the final point, and Camille and I have been discussing this, the basis of 50A is simply inconsistent with actual practice. The notion is simple, that a judge has control over the courtroom. A judge always has the ability to permit the introduction of certain materials, or on the other hand, prohibit. So 50A, for all intents and purposes, is largely unnecessary and inconsistent with typical practice.
I had the same thought as we were looking at these cases, because separate, or I guess overlapping with the FOIL cases, are the civil litigation cases that 50A was intended to address. And I just didn't see any theoretical or practical difference between what the judge was doing as he reviewed police personnel records versus medical records or versus trade secrets. I mean, the same kinds of issues. And I wasn't sure what 50A added in the litigation context that wasn't already provided with other protections, privacy and general relevance. The balancing that a trial judge does all the time. But I didn't know what you all were thinking about as a recommendation.
Maybe we could hold that. I mean, we could go right to that if you want.
I mean, some of us have thoughts. Yes.
Yeah. I mean, there are a number of ways we could go. I just wanted to put one other log on the fire before we kind of get into what do we do about this, which is just to underscore the type of information that the public's not getting. And I don't know if this went to everybody, but there have been a couple of instances in the last two years or so involving Newsday where it has gotten, in one case where it got access to an internal investigation report of the police, and in another case where it has been seeking access. Both of them have arisen out of federal litigation, where people have gone to the federal courts claiming a violation of their rights by the police and have made allegations in those pleadings. In one case, the plaintiff actually attached the internal investigation report, which they had gotten in discovery, to an amended complaint. The police immediately went in and said, "This is confidential. You can't let that be public." They were required to file an amended complaint that redacted, withheld the IAU report, removed from their pleading any specific mentions of what the IAU report found, but because of a clerical error in the clerk's office, the original complaint with the pleading attached never got removed from the public file. And many months later, a Newsday reporter who was covering the case found it Okay? And the rule is, of course, if a reporter gets something like this without violating the law, they're free to use it. And they ran a front page report, and it's a chilling story. It's a story about two police officers who went on a bar crawl on a Friday night with their girlfriends, got lost on their way back through some back streets heading home at night, and as they were doing a U-turn to try to get back to the expressway, they essentially drove a cab driver off the road to try to avoid them. He turned around and went back and yelled at them, not knowing they were police officers, rolled his window down and said, what the hell are you guys doing, or some such thing, which led to an altercation on the side of the road where one of the police officers pulled his gun out of his pants leg and shot 5 bullets through the windshield of the taxi cab, hitting the cab driver twice. The cab driver had to drive himself to the hospital with his girlfriend, who was in the front seat next to him, screaming. She called 911. By the time they got to the hospital, of course, there were swarms of police there because there had been reports issued of a policeman being, attacked. While the guy was still lying on the gurney waiting to go into the operating room to have the bullets removed from him, a police officer handed him a confession which said essentially it was his fault. The officer shot because he was trying to run the policeman down, and he claimed to be guilty. Of course, months later, the lawsuit's filed. He says none of that's true. Turns out there was an internal investigation report at the time that interviewed people who lived in the area, who saw the scene, everybody, and the internal investigation report concluded that the police were lying, that there was nothing to support their record, that the cab was actually backing away when he was shot at, and the internal investigation report concluded that there were at least, I think, 9 or 11 criminal violations by the officer and 18 or 19 administrative violations, and nothing had happened to the officer in the year or two since the report was issued by the time Newsday got it. Now, the story runs, a grand jury is convened, things happen, and there have been developments since then. But it's that type of thing which I think should give us all pause, that there's no accountability in the police department under 50A, no public accountability, and very little internal accountability. That's what I'd be interested in the experience that Franklin has from having sat on the Civilian Complaint Review Board about police accountability. But this is the type of thing that it's so antithetical to FOIL and shouldn't happen. And I could tell you about a second example where Newsday has not yet gotten the internal investigation report, but it involved a case of a young woman who was killed by her ex-boyfriend while there were 3 or 4 orders of protection outstanding. The boyfriend at the time was actually a police informant and was under the continuing supervision of the police. He was in jail, he was informing on people, and they were letting him do things like use his cell phone from jail, which was illegal, and he was using his cell phone to threaten this woman, and he eventually killed her, and he admitted to killing her. There was an internal investigation report which apparently found a number of violations by the police, and there is a wrongful death action brought on her behalf in which they sought the internal investigation report, and it was ultimately released to the plaintiffs without any requirement of confidentiality. It was they redacted it. As soon as the plaintiff's lawyer tried to publicly release it because he got it with no restrictions, they went in and got an injunction to keep him from releasing it. Very shortly after that, the case settled. The county attorneys recommended a settlement in excess of $7 million to get rid of the lawsuit. The county board refused to approve the settlement until they could read the internal investigation report to know what happened and why this justified such a large settlement. And then the most bizarre thing of all happened, because the prosecutor, the county law officer, instead of turning over the report to the police, went to the judge and asked if they could have permission to give the county board the report that was prepared by the county police, which of course the judge should have had no role in at all. And the judge told them they could only give it to them if they kept it confidential because it was civil discovery. I mean, the whole process got convoluted. At the county board meeting, the chair of the county board commenting on the settlement, saying we're going to vote for this, but it's an outrage. And he made a statement where he said a few things that were contained in the report, like something like that, and I don't have it right in front of me, so I don't remember the numbers, but something like there are 11 county police officers tonight who should be ashamed to look at themselves in the mirror. They did a number of things that violated rules. They allowed this person to use a cell phone from jail. They didn't carry out orders of protection, and it's just a shame. Something about that general. The next day, the police union went to court to hold him in contempt for revealing information that was in this confidential report, which shouldn't have been confidential in the first place. And the report still hasn't been released because when Newsday went to get it and a FOIL request, the county said, well, the judge has entered a protective order and therefore we can't get it. And they first had to go and get the judge to say, no, my protective order had nothing to do except in the context of this litigation. I wasn't trying to say it was confidential for all purposes. And then the county turned around and said, well, 50A precludes us from releasing it anyway. That's still in the courts right now. But it's just another example of the type of clearly relevant information the public has a right to know that 50A is being used to keep from the public. And I think we should be doing something about it as a committee.
There's a distinction between relevant for litigation purposes and in the public interest.
Sure.
And if 50A was designed for the litigation context, which the legislative history suggests it was, that's something judges do all the time with medical records or whatever else. It's when you get further away where it's the press interested in the public interest, where, what is the mechanism? Does it just get turned over? Who makes the decision that the use of the record, you're citing extremes where clearly the public interest is served. I'm playing devil's advocate here. What happens if you just have a notation in the record that is borderline, or at the other extreme, just embarrassing? Who makes that decision, and when, and what's the standard?
Well, I think Bob has kind of walked through one path of that, and John too, is that if you didn't have 50A, in the first instance, the question would be, would releasing this be an unwarranted invasion of privacy? Is it did some crackpot call and say, this police officer is stalking me, and, they're psychotic and it's a nothing claim? Right. That might be something that you would withhold, and the FOIA officer would have the right to withhold it. If it was something more serious and it was disclosable, and your concern is that police officers not be harassed by a lot of other issues when they testify in criminal proceedings, and I understand that's a legitimate concern, as you don't want to intimidate officers so they won't testify about what they know. There are other ways for the judge to handle that, which I think this case that, I don't know if everybody got this either, but Franklin circulated a case last Friday, People v. Oglesby, which I think is a prime example of how things should be done, where the criminal defense lawyer had certain information about other acts of wrongdoing that a police officer had been accused of, and at least one he had been found guilty of, and the judge reviewed it in camera and said, this is not relevant to this case, and I'm not going to allow it to be a part of the testimony. That's the way it should be handled. There shouldn't be a massive exemption saying nothing about the police will be covered by FOIA because we're concerned about this narrow circumstance where there might be a legitimate concern in a pending criminal trial, which we can handle through other means.
Was there a press component to this? This is the Oglesby case that actually Andrew identified. I don't think there was a press. No, it was just a straight Brady case.
Yeah.
I'll let Andrew comment. Andrew and I worked at the CCRB. He began as an investigator and worked his way up to communications director and government relations director before he fell off the wagon and went to law school.
Well, I think one of the things that is really interesting is this issue of standards and Franklin talking about who makes decisions, because I knew much less about Section 50A when I was the person who was getting calls from the press about police records than was even contained in like the week of reading stuff preparing for this meeting. There's very little training on the ground level of someone who's the press officer about where the contours of this do and don't fall. There's just a blanket statement usually that everything we do is covered by Section 50A. And going back and reading 50A, I'm not even sure CCRB, which is not a police agency, their own internal records that don't come from the police department, their own interviews, their own statements from officers, I don't know that it's covered by that even in the first instance, and yet we never were told anything like that. So you end up having very eclectic decision-making by an individual making decisions when he gets calls from the press of like whether he thinks something should or shouldn't be this balancing act, but I'm not sure I was necessarily competent 10 years ago making those decisions to be making them. But that's what was going on, and so I'm really interested in seeing all this as being someone who was confronted with, now I'm making this decision about what is and isn't before it even gets to a FOIL officer, just a call from a reporter. So I think having some sense of what the standard should be is necessary to let people feel they can do a productive job.
Mr. Case, I think what you're getting at is what occurs so often these days, and that's the knee-jerk reaction where a law enforcement agency will simply say no. And I think that you're right. There is very little education. There are very few standards. But going back to a couple of things that Dave was mentioning and another point really to build upon what Franklin was suggesting, I've said 1,000 times publicly that embarrassment is not one of the grounds for denial under FOIL. If that were so, there would be very little that would be disclosed about public employees at all. God knows, at this point, my salary is embarrassing, but it's public. It's public. Yeah, you're laughing. You don't know why. But the other point, and the Court of Appeals has made this clear in other contexts, FOIL is an apple, and other disclosure devices are oranges. What you get under FOIL is different from what you may get in discovery. And the standards, as you know, are completely different. In discovery, you get what is material and necessary. In FOIL, you get what any member of the public can get. And all of that is obliterated by 50A. And again, going back to Franklin's point, it seems to reduce the ability, the statute is based upon the inability of the court really to determine what's public and what's not until a controversy has occurred.
Yeah, what guidance is offered to a court on a FOIL decision? It's just ever expansive.
In terms of if you were litigating under FOIL?
If you're just litigating FOIL, just the public interest, that's your Hearst case. That's your Court of Appeals case.
Yeah. Well, what happens, I think, in the FOIL cases under 50A, the way it is now, is that all of the litigation ends up being around, is this a personnel file or not? Because the way the statute's written, if it's a personnel file, it is, quote, confidential. I mean, I think that to go back to how you could correct this, there are a number of ways to correct it. One would be just to repeal 50A. And as John was making the point, that probably is the cleanest and best because the concern the legislature had is addressed by other mechanisms, so it really is an unnecessary statute. I think there would be other ways to do it. One is to get rid of that notion that it's totally confidential and come up with a different approach that both defines a personnel record and talks about the circumstances in which it's not disclosable, which is not just that it's a blanket confidentiality, but it's not disclosable in under certain limited conditions, which I don't really favor because it seems to me if you go down that road, the conditions are going to tie to its intended use, and we typically try to avoid that, although it's inevitable when you're talking about privacy, it's already there. You have to, when deciding whether something's unwarranted necessarily requires a court to balance the public interest against the privacy interest, which requires, in most cases, some understanding of why the information is needed. So you could go that route, I mean, because this really is in the nature of a privacy-type exemption, and take away the blanket confidentiality and put in some language there about its proposed use.
One of these cases in our summaries, though, said, and I think it was the Court of Appeals said, it's the use that they're focusing on. It's not who asked for it, it is the use.
The Daily Gazette case.
Yeah.
I think,
yeah. So it's the opposite of what you're saying, because they're concerned, because underlying 50A was the concern of the abuse of it in the context of litigation.
And Daily Gazette really was a turning point in the case law, I think, because that sense of use and how it's going to be used had been imposed by the Court of Appeals 15 years earlier as really, or 20 years earlier, I think it was the Burns case, where they said that this is a way to further narrow it. And in Gazette it was used actually to broaden the scope because that abusive use concept was opened up to go beyond the courtroom setting. And it's been used by courts and misread by courts since then to really mean anything that might be considered abusive.
In playing on Bob's point about apples and oranges, I mean, I really think that a remedy that would make sense and actually would serve everybody's interests is to recognize that these are apples and oranges and say, propose that 50A be repealed in its current form, which is an amendment to FOIL, and that a language be developed to amend the criminal procedure law to prohibit the use of certain types of records in a lawsuit, which would take away any incentive for defense lawyers to use FOIL to get the stuff if they can't use it. But to put it in the criminal procedure law or the evidence law somewhere separate from FOIL, because it's really not a FOIL issue. The concern that drove this was the misuse of this or an abusive use of this in a way that would interfere with the criminal justice system. So that's where the remedy should be, is in the criminal justice system, not in FOIL.
And then the other thing you'd have to address is when 50A was amended to bring in the corrections officers, there's a lot of legislative history about their personal safety or the safety of their families because of their address information. That could be also addressed through the FOIL law by
the privacy amendment. I
mean,
mean,
by amending the privacy law.
Existing privacy.
That's right. Or even by the existing one.
I was thinking of another approach for political reasons, I suppose. I don't know how willing the state legislature would be to repeal the 50A in its entirety, but I would hope that the argument could be made that based upon the initial legislative intent, since the idea is to regulate disclosure in a litigation context, the initial subdivision of 50A could be amended by referring to all these classes of public employees, but removing the reference to confidentiality and indicating that when any of these records are requested in a litigation context, then we go to subdivision 2. Prior to issuing a court order, the judge has to review the records to determine what's relevant and what's not, what should be admitted, what shouldn't be. Just a thought, and I'll reduce this to writing if you think that may have some merit.
See, I think the problem with that approach, Bob, is that the deciding whether it's relevant and stuff, the only judge who can do that is the judge who has the pending case, and that typically wouldn't be the judge with the Article 78. You know what I mean? If you leave it in the FOIL law, it's going to be litigated independent of whatever ongoing litigation is going on. You need to get that into the litigation context, which is why I would figure out a way to move that provision somewhere
But again,
else.
if a member of the news media or somebody else is requesting a record indicating that discipline was imposed against a particular police officer, and it has nothing to do with litigation, under FOIL, that would be available now. You wouldn't have to reach that point based upon existing precedent that pertains to all classes of public employees except those that are subject to 50A. So the only time that 50A would be triggered is if a request is made in the context of litigation itself.
That's a good idea.
Which is what the legislative history suggests, because there's otherwise no reason to distinguish between you and a police officer, because a police officer's on the stand a lot, and hopefully you're not.
See, here's the problem I see, Bob, and I don't mean to be a roadblock, but
You're allowed.
It becomes very difficult, I think, to define what a litigation context is. If you're in a litigation, if you're a criminal defendant and you have your cousin file a request without saying anything, is that in a litigation context? It becomes very difficult to enforce. And it seems to me the cleanest way to accomplish what we want to accomplish would be to create the restrictions against use in the litigation procedure laws, because then you remove the incentive to seek it. You know, if I'm the lawyer for the criminal defendant and I know I'm not going to be able to use it in litigation, then why would I bother going to get it through anybody? You know what I mean? That would be an effective way to stop the misuse. And I think the other way just raises all sorts of enforcement questions and what kind of evidentiary, how do you get evidence to prove that it's not in the litigation context if the agency says, well, you know, we think you're really, this is a charade because you're related to so-and-so, or, you know, your law partner has this case going, and how do we know that you're not helping your law partner? It just becomes very muddy.
I don't disagree, but if that's so, it seems to me that you would need amendments that relate both to the criminal procedure context as well as civil, because there are cases that, like the civil rights case that you mentioned a moment ago, that Newsday broke. the plaintiffs are not involved in the criminal procedural law. They're involved now in civil litigation. But
right. But again, that's why I think that John is right that this is really belts and suspenders, because in the litigation context, judges typically control what can be, and they're not going to let you go that far afield.
Right.
So and you know these cases I mentioned with Newsday, the information they got, they would get under any standard. It's directly relevant to the lawsuit that was going on.
But what if there's no lawsuit? It's a FOIL request going to the likes of Andrew in his younger days. What standard is he to apply? Is he the one making the decision, the relatively low-level agency person?
No,
the FOIL
no,
officer.
There's
and
a
what
press officer,
standard?
and then I say no, and then they go to the FOIL officer.
But it's and equally, I don't want to say untrained, but not overtrained person. And what standard are they going to apply? And where are they going to draw it from? From the privacy exception to FOIL?
Yeah. I'd just like to go back briefly to the case that I have pending now. That's we got the third department decision, because that's somewhat relevant. I mean, it's a way in which someone could point to a litigation other than a criminal prosecution. This is the one involving the New York State trooper that killed somebody when he was drinking off duty. He was then sued by the family of the deceased in a private tort action after he had left the police department. And one of the things that he was claiming, that one of the reasons why 50A applies, is because the records could be used abusively against him in the context of that private tort action. And that, again, it has nothing to do with the purposes of 50A at all. And that decision is just another example of the scope creep, because there you have the appellate division said two things that no appellate court has ever said before. Number one, that this statute applies to former officers, and where there's no rationale for it applying to former officers. And number two, that those former officers are necessary parties, which means that you're going to have every single FOIL case from now on that involves 50A, where courts, if they follow that decision, will say, you have to join the police officer individually. And this will bring in an entire extra layer of litigation and dispute if they are joined as necessary parties. And that's not required by the statute either. The statute is very clear that you only get to them being necessary parties if you're in the context of a litigation, whether you're seeking records, and there's already been a determination that they are personnel records, not if you're still dealing with the question of whether they are. So the scope creep continues, and the use of ancillary litigation is very real, I think, as a way to, to Dave's point here, that they might look to other litigation, whether it's a FOIL litigation, whether or not it's private litigation that has nothing to do with the circumstances, to say that it still applies.
What do all you public employees in Albany think? Will not hear me.
I know what I think. I think 50A should simply be repealed, so that the people covered by 50A are treated in the same way as all other public employees, which would mean in a litigation context as well as a FOIL context.
Is there anyone in Albany that would lead that charge?
Well, that depends upon what the committee recommends. If that is the recommendation, certainly that would be made in our next and upcoming annual report.
I mean, is there anyone in the legislature that would lead the charge?
I think that there may be, but I'm not sure. I think that there may be. Some of you, I'm sure, have read about the New York City Police Department's involvement in, let's say, activities abroad that may relate to the possibility of terrorism, as well as the infiltration of the Muslim community, not only in New York but elsewhere. I'm aware of a senator's office that has been, let's say, more than troubled by that. And we've talked briefly about 50A and that it serves as a bar. My hope would be that there would be somebody in the legislature who might lead the charge. I don't know.
Well, and this has been a recommendation of the committee in years past. Years ago, this was a consistent recommendation included in the committee's annual report. And correct me if I'm wrong, but there was at least one occasion when a senator brought it up, introduced it into a bill in the state legislature. It didn't go anywhere, but it has been introduced on occasion.
Can you pull those materials together for us before we...
Sure.
So that we're at least consistent with whatever we recommend, or not inconsistent?
Not inconsistent unintentionally.
Unintentionally with what we've said in the past, or at least we know.
I don't know that inconsistency is necessarily critical because of what Jonathan and all of you have suggested, and that is that the scope, the creep of 50A has changed things. You know, in the olden days, it seemed that we sort of knew what the scope of 50A was, but I'm not sure that we do anymore.
What's the status of your statement, embarrassment is not a defense to FOIL? Refresh me on what would, if you had something embarrassing in your personnel file that Hearst Papers was trying to get at, what would be the standard applied?
Well, again,
and who would apply it?
Well, the standard typically is unwarranted invasion of personal privacy. And in fact, coupled with that is the exception involving intra-agency materials. And in a nutshell, those elements of intra-agency materials that consist of opinion, recommendation, suggestion, conjecture can be withheld. On the other hand, statistics and facts, as well as final agency determinations, are public. We couple that with the exception involving unwarranted invasions of personal privacy and come up with sort of a dividing line between factual information, determinations, as opposed to, again, on the other side, the opinions, the recommendations, etc. A typical example, and this has come up, ratings. You remember, Dave remembers the cases involving the ratings of teachers. Some of that has changed due to legislation, but we still get lots of inquiries concerning performance evaluations of superintendents of schools, among others. And on the one hand, the subjective expression of opinion by the reviewer concerning how well or poorly so-and-so has done the job, in our view, is out of bounds. It can be withheld. It's intra-agency material. On the other hand, the final rating, which may be a score, it may be a number. In the case of people like me, years ago, a box was checked off by the boss at the bottom of the evaluation form, ranging from terrible at one end to outstanding at the other. If that was final, we have advised that is public, and the courts have essentially agreed. Dave, you remember the Mulgrew case, the case involving the teachers' union, where that was the conclusion reached by both the Supreme Court and the Appellate Division. Now, is a final rating of needs improvement embarrassing? Yes, it is. But as a public employee, again, courts have found in numerous contexts that we have less privacy than others because we're supposed to be more accountable than others. And in the context of something like that, certainly the public should have the ability to know whether so-and-so is doing a terrific job or, let's say, a not-so-good job.
And that decision is being made by a FOIL officer without notice to you?
Yes, that's correct. That's correct, because, again, it's the nature of the record that determines what's public and what's not. The interest of the applicant also, generally speaking, has no bearing on what's public and what's not.
Perhaps a recommendation might address changes to 50A as opposed to just asking legislators to get rid of it, because I think that maybe if it's specifically said that it had to be applied only in a court setting or only in court litigation, then it would limit how it could be used, as opposed to having a local police department determining, well, 50A prevents me from giving you this information.
But we have the problems you pointed out. But it's going to be more politically.
I think the problem with that is what Dave mentioned. What if the request appears to be made for purposes other than litigation, but it's your friend who makes the request more or less on your behalf, and you are involved in litigation? Would you agree with that, Dave? That presents a potential problem?
Yeah, I do.
Yeah.
I mean, I guess maybe what we should do is look at 50A in context. I mean, if there's an advantage to coming up with a proposal that looks like a modification rather than an appeal because somehow the optics are better, there might be a way to accomplish that. But we'd have to look. At the moment, I don't have 50A right in front of me in terms of where it fits in. But there might be a way to do it, to simplify it. But I guess one thing, Bob, is just we should get a sense of whether people are in agreement that we should be including this in the report, and then if we are, maybe between now and the next meeting, come up with a couple of alternative approaches that are more concrete, and we could walk through the pros and cons of them.
Okay. I just think that a modification rather than an appeal would probably be easier to accept when we're addressing this with our legislators.
Yeah, and I think that's a real concern. I can predict with high degree of confidence that the police union will be all over this.
Apoplectic.
And that's why it's important to have in the proposal provisions that address their concerns. They do have some legitimate concerns, and we shouldn't, I mean, I do think one answer is already taken care of, but I think we can go further than that to say, no, we understand what you're saying, but this is too broad, and they won't ever acknowledge that because they've been using it to really shut down reporting about police misconduct, and that's the problem, is how they are affirmatively using it. We have to realize, though, that they will be very opposed to any change.
Certainly, from a public point of view, I don't know how this translates into the legislators, but the opinion of police privacy and the rights of policemen is at an all-time low from the years that I've been in the city. I mean, that's been a big issue in our mayoral campaign is the view of the privileges of the police, and shining a light on police activity is there's certainly a lot of interest in that. So maybe it's as good a time as there will ever be. On the other hand, they're still pretty powerful. Those unions are actually perhaps going to be more powerful in the next mayoral reign.
Not the PBA.
Not the PBA.
Reality really gets in the way too much, doesn't it?
Yes.
So there's no, or I want to say it in the negative, there's no objection to having something in our annual report. And if we came up with some written proposals that we floated before our next meeting, maybe that's a good way to handle a more linear discussion about what we want in the annual report.
That makes sense to me.
Yeah, certainly we want to make a lot of the conceptual points that have been made here today. That in what way why are police officers being treated differently? Okay, there was this one narrow reason underlying 50A, which is now correct. It seems to me we can say, we should say all of that. And then the question is, what's the fix? And is there anything that's palatable? Or maybe we don't care. Maybe we just make our recommendation and help the legislators arrive at something palatable. Mm-hmm. If we find a sponsor.
And that needs to be supported.
And I think comparing and contrasting them with other public employees and other states. Yeah. A lot of other states are where we are.
Yeah, I think there's a lot of information to put in front of the legislature to kind of frame this issue for them.
I agree, Dave. I agree, and my guess is that we can come up with several alternative proposals And the hope is that one of them might attract some attention and might even be palatable in terms of the introduction of legislation. The other hope would be that since we have representatives of news media organizations sitting at the table in New York City, the hope would be that there would be some, let's say, editorial or public support for these changes. Certainly, if members of the public get in touch with their legislators, that makes a difference in terms of the possibility of supporting a bill.
Put it back on you.
I have no doubt where the editorial board of the Albany Times Union stands on these issues. Be happy to bring it to them.
Yeah, I should say also that the David McCraw at the New York Times is very interested in this issue as well, and he was going to come this morning and had a last-minute problem. But I have a feeling there would be broad editorial support around the state for this if we came up with a specific proposal.
I would hope so. So the next step, I suppose, and I would hope that if any of you have recommendations for a proposal, thoughts, etc., please send them to Camille and myself so that we can develop something for the next meeting in which we offer the background, the justification, and let's hope a series of alternatives. Is that palatable with all of you?
I think so.
Does the legislative history address why the legislature thought they needed 50A to protect the police officers from this abuse and litigation with criminal defense lawyers as opposed to relying on existing law? Because that's...
I mean, was it the result of a particular case?
Yeah, I mean, our argument is it's belt and suspenders. I guess my question is, why didn't the legislature feel that when they enacted 50A, even before creep set in?
I can tell you why, I think. Because the unions are tougher than the rest of us. I think that that's the reality of it. And yeah, the Court of Appeals in one or more cases referred to the express legislative intent to protect against vexatious and harassing disclosures made in a litigation context. But the Court of Appeals never explained why the courts didn't have control within their own courtrooms. That simply did not come up. The only case I've read that dealt with that at all was the one that you just sent us on Friday, where the judge obviously expressed concern.
And in the subsequent amendments, certainly the language got looser and looser, and there was no specific rationale for why firefighters or paramedics should be joined under this. Yeah.
Well, that's the creep that I'm afraid of. Next, who will it be? Teachers, sanitation workers? I don't know.
Hospital employees.
Excuse me?
Hospital employees.
Hospital employees, whatever. Whatever.
Yeah, we already have the paramedics.
That's right. All right,
So
another question. Go ahead, Jean.
Well, I was going to say, what else should we be thinking about?
Well, that was my question. What other topics do you think would be ripe for consideration in an annual report, so that we can prepare for not only this issue but other issues at the next meeting?
I think we should continue the theme we had the last couple of years about moving from pull to push, and I haven't really kept track of the governor's initiatives and how they've been implemented, but it would seem to me that we should comment on those and see if there are areas where we think they haven't gone far enough, and keep some pressure on that, because that's really the major change that's occurring around the country, and New York should be on that train.
I would agree with that, certainly. The other element that I think is important, and we have a proposal or two, involves the initiation of litigation under FOIL. And one of the recommendations involved expediting, if you will, the appeal process by requiring an agency that has lost in the first round to make a determination to appeal quickly, so that the litigation doesn't drag on forever, so that access delayed is the equivalent of access denied. And there has been some support for that proposal in the legislature in the past. Sooner or later, maybe somebody will pick up the ball and actually run with it.
Are there
Other thoughts? Yeah.
Back to the pull to push. We've made such leaps in the last 2 years. It's really been astounding. But it'd be nice to know where there's still pockets of problems that we can point to.
I think that the pocket of problems involve two realities. Yes, the governor has issued an executive order dealing with open data, which applies to state agencies. It does not apply to local governments. There are several local governments that have jumped on the bandwagon and joined, but there is no obligation to do so. The other point is that an executive order is great, but it could be revoked. It could be withdrawn. The next governor could say, I don't care, I don't like this. And more important, in my opinion, better would be a statute as opposed to the executive order. The other point is that, it's true that agencies now routinely post a variety of records on their websites. The notion of proactive disclosure, again, there is no obligation to do so. And, in the best of all worlds, there would be a statute that would require it.
Are we going to come up with proposed statutory language to move it forward?
Well, we have in the past. Yeah.
We had a slightly different one where it involved we were drafting language about whether the information was frequently requested, public interest. What were some of the other phrases that
frequently
we used?
requested, clearly public, and significant.
We did have a recommendation for a while about records like that prior to the push for open data.
I guess I'm just thinking about Bob's comment about the executive order could be revoked and whether it would be worth looking at the executive order and come up with statutory language that at least would make the executive order permanent and perhaps extend it to local governments, whatever the scope of that is, as putting a marker in and at least there won't be any backsliding, and then see how we might expand it or where there's a need to expand it.
But I just want to be clear that initiative pertains to data collected and managed in a database, as opposed to records that may or may not be maintained in a numerical or a statistical manner. So I don't want to forget the records that we have that are frequently requested, significant, those kind of things.
I think proactive disclosure is related. Proactive disclosure is related to open data, but it's a separate kind of concept.
Right.
And one of the points, I deal with this, we think about it all the time, and some of the potential resistance obviously comes from government agencies, particularly local governments, that say, well, gee, this is going to cost some money, we don't have the resources, we don't have the expertise. That may be true, but at the same time, and we've talked about this a lot, the pace of change is so dramatic that what may be difficult or impossible today becomes the norm tomorrow. And you may recall a few years ago, New York was the first state to enact a provision that says, government agency, if you can accept a request made via email, yes, you must. If you have the ability to transmit records via email, yes, you must. Why did we put in the if you can? Because when that was recommended in 2005, there were dozens of units of local government that did not yet partake in the use of email. Now it's a part of everybody's life. And my guess is that the same will be so with respect to these other issues. Open data, proactive disclosure, it should become the norm.
Well, and we should continue to the extent we can to underscore the cost savings that it will ultimately reap, because it is a bit of a chicken and egg, that it may take some upfront money, but in the long run, it's going to be a big cost savings. So.
Sure. The point that's been made so many times, every time records are posted on a government agency website, nobody has to make a FOIL request. The government doesn't have to respond to the request. Everybody wins. And that, I think, is a concept that's pretty easy to understand. We ask for more. Anything. Anybody.
I think at our next meeting we should go through the specific proposals from last year again, like we always do, and do our reporter's lead.
Because I haven't read it last year.
Bear with us on our scheduling emails for our next meeting. We are gonna try and get these set up, unless you feel like talking about calendars now, although that may not be possible. But bear with us. Wendy will be sending around emails again about our next meeting.
Bob, when you do your CLE with FOIL officers, what issues are you hearing from them that they're struggling with?
It's so interesting. It will vary. I can do the same kind of group 2 days in a row, and the questions will be completely different from one situation to the next. One of the issues, and we've talked about this in the past, involves the reality that agencies now, in many instances, receive many more requests than they used to receive. FOIL in a lot of agencies has become something of an industry, and their ability to comply, let's say, in a timely manner, has become increasingly difficult, especially in agencies where there have been reductions in staff, and where lots of people, for better or for worse, have left state government, they've retired, and they've taken their knowledge and expertise with them. So one of the things that we hear very simply involves the realities associated with constantly increasing use of FOIL. At the local government level, we hear different kinds of issues. In some parts of the state, the issue involves hydrofracking. In others, it may be windmills. So much is dependent upon what happens to be going on within a particular area. So it's very interesting and never ending. I wish I could give you a better answer. I'll be doing a couple of CLEs soon. I'm doing one for the Bar Association in early October, and my guess is that most of those in attendance will not be government officials. Then I'm doing one at the end of the month, sponsored by the Attorney General, and that will be open to state agency attorneys. So I'll have the ability to sort of compare the kinds of question that they raise and what ails them. Let's put it that way.
Are those in New York City?
The Bar Association is here, but I believe that it will be available online. The Attorney General's session is always available via webcast and online for attorneys who want to partake.
Send around that information.
Sure. Yeah, I'll send you information regarding the scheduling of the CLEs if you'd like.
Wendy just handed me a note. It looks like we're tentatively on for October 22nd and November 14th.
Wow.
October 20, what was that date again?
22, October 22 and November 14.
And November 14.
Oh, that means I'm missing both days. Yeah.
I can't make one of those either.
Frankly, I can't make the October.
Those are.
I can't make the 22nd.
All right. Let's be fluid about that then. I think that we need everybody, but we need the two of you especially.
Well, let's try and rework that October
Yeah.
27
Yeah.
date for that purpose.
Okay.
We'll try to do.
Wendy will be in touch.
I don't think the 14th works either. That's right in the middle of PLI.
Yeah, Dave's out both of those
date I
dates.
couldn't do it.
Well, we can try and rework
I'm going to
both.
be on a plane, so there's no logging in.
Might be
All
on a
right.
plane,
Well,
huh?
let's hold. If we could hold those dates as a backup, worst case scenario, and then let's try and rework both of them so we can include Franklin in do our best.
Excuse me. Camille just mentioned minutes. We have minutes from the last meeting. We have minutes actually from 3 meetings.
De Blasio.
Yes. Thank you. I don't know if anybody has read them.
Thompson is conceding to
And I-
De Blasio.
Hmm?
Thompson is conceding to De Blasio.
Oh, really?
Just came across.
Ah, over.
Okay. Franklin is always connected.
What?
I said Franklin is always connected.
Well, when I was checking my calendar and I just saw that Thompson is conceding to De Blasio, which is of some interest to those of us in New York City.
Yeah.
By the way, and some of you may know this, de Blasio did what amounted to a report card involving the level of compliance with FOIL by New York City departments. And he didn't pull any punches. He didn't pull any punches. They got grades in various areas ranging from A to F. So it seems that he has had a significant interest in improving compliance with FOIL, at least in city government.
He's also very interested in police officers. When I was on the he was my city councilman. And when Andrew and I were at the CCRB, he wrote, I didn't always agree with everything he wrote, but he wrote quite a bit about the police misconduct and police oversight. So it's an issue he's particularly interested in, and is definitely not on the side of the unions, or at least wasn't before he ran for mayor. I can't say where he might be right now. But would you send us the link to that? I'd be interested if you can find it to de Blasio's report.
Sure.
'Cause I don't know if I read it up, I have forgotten it. You know, we still have the public advocate, and I actually like both candidates for that, Squadron and Tish James. That office has a $2.3 million budget, and the runoff is going to cost $20 million. And now it's just the one.
Huh. Seems kind of crazy. I've had to say this in many training sessions. One of the myths that we hear all the time involves the approval of minutes. There's no law that says that minutes have to be approved. We do so based upon history, policy, but not law. If there is a motion to approve the minutes of the last meeting or the last 3, that would be fine. If not, it doesn't really matter.
And do we even have a quorum?
Yeah, we do. Anybody interested in moving to approve the minutes? That's the case. Should there be a motion to adjourn?
So moved.
So moved. Thank you all so much. This has been, I think, a terrific meeting. And I hope that the new members agree.
Absolutely.
Good.
Thank
Till
you,
we
Bob.
meet again.
Great. Thank you again.
Thanks very much.
See if we can find the off button.